A stranger walks up, hands you an envelope, and says 4 words, "You've been served." Your stomach drops. Inside is a lawsuit with your name on it. So now what? Today, I shall walk you through exactly what happens next. First, a calming breath. This is a civil lawsuit, not a crime. Nobody's coming to arrest you. This is a dispute over money or harm, one person says. Another wronged them, and they want a court to sort it out. Let me name the players, because you'll hear these words constantly. The person who sues is the plaintiff. The person being sued, in this case, you, is the defendant. 2 sides, 1 disagreement, and a courthouse in the middle. Most people get one crucial bit wrong. A lawsuit isn't a single dramatic courtroom showdown like the telly. It's a long, slow, expensive journey with many stops, and the vast majority never reach a trial at all. Stay with me. I shall be your guide through that journey, stage by stage, from the moment that envelope lands to the final verdict and beyond. By the end, you'll understand the whole machine, and why it almost never ends the way films suggest. Stage 1 begins before you ever see that envelope. The plaintiff files a document called the complaint. It's the opening story. It lists who they're suing, what they claim went wrong, and exactly what they want the court to do about it. But here's a catch. You can't sue about something forever. Every type of claim has a deadline called the statute of limitations. Miss it by even a day, and the case can be thrown out before it begins, no matter how strong. Once the complaint is filed, the court must tell you about it. That's the serving you witnessed at the start. You receive the complaint and a summons, an official notice that says, in essence, respond or risk losing automatically. That phrase matters. If you ignore a lawsuit, you don't make it disappear, you hand the other side a default judgment. The court can rule against you simply because you didn't show up, so never, ever bin that envelope. Respond. Stage 2 is your turn to speak. You file a document called the answer. Line by line, you respond to the plaintiff's claims, admitting what's true, denying what isn't, and raising any defenses of your own. The battle lines are drawn. Or, rather cleverly, you might not answer at all yet. Instead, your lawyer files a motion to dismiss, arguing that even if everything the plaintiff says were true, there's still no real case here. If the judge agrees, it ends. Splendid. Most cases survive that first challenge, though. The judge says, in effect, this is worth examining, and waves both sides forward. And now we enter the longest, costliest, most misunderstood stage of the entire process. Brace yourself. Stage 3 is discovery, and this, you'll find, is where lawsuits actually live. Forget the dramatic trial. Discovery is the long middle where both sides dig up evidence, hand over documents, and pry into each other's version of events. First tool, document requests. Each side can demand the other's relevant paperwork, emails, contracts, receipts, text messages, records. In big cases, this can mean millions of pages. Yes, millions. The truth, it turns out, is buried in paperwork. Second tool, interrogatories. A frightfully formal word for written questions. One side sends the other a list of questions, and they must answer in writing, under oath. Lie here, and you're not just wrong, you've committed perjury. Mind how you go. Third tool, and the dramatic one, the deposition. A witness sits in a room, swears to tell the truth, and answers a lawyer's questions out loud for hours while a court reporter records every single word. No judge, no jury, just sworn testimony. Why does discovery matter so much? Because by the end of it, there are very few surprises left. Both sides see the other's evidence, the strengths, the weaknesses, the smoking guns. And once you know how strong your case really is, the maths begins. But all this digging has a price, an enormous one. Lawyers bill by the hour, experts charge fortunes, and the paperwork never sleeps. Discovery is precisely why lawsuits cost so dreadfully much, and why so many people settle just to make it stop. Stage 4. Pre-trial motions. Before any trial happens, lawyers ask the judge to make rulings that could shrink or even end the case. The headline one is called summary judgment. It's a powerful shortcut and worth understanding properly. Summary judgment says this: Your Honor, the facts here aren't even in dispute. Apply the law and there's nothing for a jury to decide, so rule now and skip the trial. If the judge agrees, one side wins right there, no trial at all. Often, though, the facts genuinely are disputed. One side says the light was green, the other swears it was red. When a real factual fight remains, the judge can't decide it alone. That's exactly what trials are for. So, we press on. Now, the part nobody puts in the movies, and the single most important thing to understand. Stage 5 is settlement, and it's where over 95% of civil cases actually end. Most lawsuits never see a courtroom at all. Why so many? Because by now, both sides have seen the evidence and counted the cost. A trial is a coin flip in front of strangers, slow, public, and brutally expensive. A settlement is certain. Many would rather take a sure result than gamble. Settlement is simply a deal. The defendant pays an agreed sum, the plaintiff drops the case, and everyone avoids the lottery of trial. Lawyers negotiate, numbers fly back and forth, and somewhere in the middle, two reluctant sides usually find a handshake. And here's a money detail worth knowing. Many plaintiffs hire their lawyer on a contingency fee. The lawyer takes nothing up front, then collects roughly a third of any winnings. No win, no fee. It lets ordinary people afford to sue at all. But say no deal is reached. Then, and only then, we arrive at stage 6, the trial. The very thing everyone pictures, and the thing that almost never happens. Here, finally, the dispute is decided in open court. Let me show you how. Two flavors exist. In a bench trial, the judge alone decides. In a jury trial, 12 ordinary citizens hear the evidence and reach the verdict, with the judge refereeing the rules. Either way, both sides now tell their full story aloud. Each side gives an opening statement, then calls witnesses, presents evidence, and cross-examines the other's witnesses, the tense bit where a lawyer pokes holes in a story. Finally, both deliver closing arguments. It's structured, slow, and surprisingly unlike the telly. Now, the crucial difference from criminal cases. To win, the plaintiff doesn't have to prove things beyond a reasonable doubt. They only need a preponderance of the evidence, meaning more likely than not. Tip the scales past 50% and they win. That's a much lower bar than a criminal trial, and it explains a curiosity. Someone can be found not guilty of a crime, yet still lose a civil suit over the very same event. Different question, different standard, different result. Frightfully important to grasp. Stage 7, the verdict. The judge or jury decides who wins. If the plaintiff prevails, the big question becomes damages, the money the losing side must pay. And there are two quite different kinds, so let's untangle them. First, compensatory damages, money to cover real, actual losses. Medical bills, lost wages, repair costs, the measurable harm someone genuinely suffered. The goal here isn't punishment. It's simply to make the injured side whole again, as if the harm hadn't happened. Second, and far rarer, punitive damages. These exist not to repay losses, but to punish truly outrageous behavior and warn others off doing the same. They only appear in serious cases, but when they do, the numbers can be eye-watering. Then, one famous example. In the 1990s, a woman badly burned by scalding coffee won millions, mostly in punitive damages. People mocked it as frivolous, but the company had ignored hundreds of prior burn complaints. The full story is rather more serious. And even a verdict isn't always the end. The losing side can appeal, asking a higher court to review whether the law was applied correctly. An appeal isn't a do-over of the facts, it's a careful second look at the legal reasoning. Justice, double-checked. So what does all this mean for you practically? First, the golden rule we began with, if you're ever served, never ignore it. Read it, note the deadline, and respond. Silence is the one mistake that guarantees you lose. Second, know the small door. For minor disputes, unpaid deposits, modest debts, there's small claims court. It's cheaper, faster, and built for ordinary people to argue their own case without a lawyer at all, a frightfully handy thing to remember. Third, remember the real shape of it. Lawsuits are slow, costly journeys that overwhelmingly end in a settlement, not a thunderclap verdict. Knowing that takes away the fear and replaces it with something far more useful, understanding. And understanding, my dear viewer, is power. Quick recap then. A complaint and summons begin it. An answer responds. Discovery digs up the truth. Motions trim the case. Most settle. A rare few reach trial, decided on a preponderance of evidence. Then a verdict, damages, and a possible appeal. Do bear in mind, this is education, not legal advice, and laws vary by place. If you ever face a real lawsuit, talk to an actual lawyer. Now, a question for you below. Have you ever been to court, even small claims? Do tell.